Get ready all your questions. He himself wants to be challenged and wants to listen rather than just talking. So it's not a one-way thing. So again, officially, rather, good morning to everybody. Good morning.
Good morning.
Good morning, Mr. Sukumaran. Welcome to this first, but hopefully we have many more with Mr. Vanugopal regarding the very pertinent issue of Sarawak autonomy. Many people told me that it's already stale. I don't think so. I think there was a lot more. Okay, so let me first before I introduce this one, Mr. Vanugopal to you, I would like to share a little bit. Okay, that's very normal for institute like this. Okay, basically, I personally feel that Sarawak autonomy has been gone through a phase of a bit what I call maturity. I'm glad the Chinese community, like through Richard and so on, they are organizing it now. When we first told him do something, because our Chinese has nothing much yet at that time. And I remember with J.C. Bong and David Tang at the time, one of the key things that came out from that seminar was political education, or rather constitutional education, which need to be pervasive in our society. In other words, we must have it so that our next generation will know more and specifically. And of course, this has to go on. So it's not sterile. It's not something that's infertile. It's still strong. It's still fertile. It's still good for us and for the future generation as well. That's why I reserve the privilege and right to have him over and perhaps for more. Yeah. And okay, personally, as you know, we are institute, Saki Research Institute, which is quite a new one. Now our stress is on research and probably to provide a think tank service to some of the people who are willing or more liberal open to us, especially some of our ministers. Yeah, I'm the director as well as the by name also by by appointment. Okay, now my point is this. Before we ask Mr. Vanugopal, is this: in order to understand Sarawak autonomy and the related issues, the hundreds of issues now, the Pandora box seems to be open, right? Malaysian agreement and the RFC. I use the word vandalize it. In British, they use the word vandalize it, or vandalize constitution. In other words, we need a lot more research, a lot more scholarship on it. And Mr. Vanugopal in 2012 or 13 has gone into it. And come up with a book. The book is a hard copy and by Sweet and Maxwell. It's a solid book. But the book that attracts me literally, important thing is the theoretical framework. Some of you may be surprised by this. See, to study this thing, we need to know different doctrines. Okay, offhand I can tell you, doctrine of unconscionability, doctrine of void statute, doctrine of colorable legislation, doctrine of pith and substance, and doctrine of severability. This is not from me. I learned from him through this book. Okay, so it becomes a theoretical framework for us to study deeper, and we will be on track. Because all these doctrines, these principles, are legal based, And once we know it, we are able to tap into the whole issue and make sure we're on track and on the legal foundation. For example, his book is a lot based on Indian constitution, Indian laws, which is far ahead of us. So he has bring out the precedents, the cases for us to learn, for us to go deeper. In other words, we'll be on the right legal foundation. Most of us, over the last 5-6 years, we more or less talk about sociological problems and how to tackle it and so on. There are some legal aspects talking about it, but it's not theoretical based. It's not theoretical. For us, I can tell you, for a scholar, if we don't have a theory, we have no tool for analysis. And we found, there are a lot of PhD students, master students, they fail their thesis because they don't have a good theory. Second chapter. If they don't have it, they're out. So, Mr. Vanugopal has kind put to us easily and very readable sense about the doctrines, about the theories. Personally, I added a few, which is I hope to share. I have my own copy of this, which is not processed yet. So if you guys want to buy this, it's $10, because we have to cover the cost. Sorry, this one is also non-profit because the cover itself is $6, and then we want to pay some to the contributor. So now the idea is very clear. There are different doctrines. When we negotiate about Sarawak autonomy. We are in the process of negotiating by amendments, by devolution of power, by other means, right? By political means. So now let's be clear. There are some doctrines called good faith, duty of good faith. It's very important in the negotiation process. Lawyers will know that. I happen to be in the subfield of legal fraternity as a political scientist, so we know good faith is important in the process, and it has a legal relevance. It's not just a good word or good faith, good faith. Secondly, is doctrine of best endeavors. This is also a doctrine legally binding, especially contractual things. Like negotiation is actually a contract, okay? So negotiation of autonomy is also a contract. So good faith, best endeavors, I'm not talking about good endeavors, it's the best endeavors, as well as the last one is the time of essence. The doctrine of time of essence, obviously now we are aiming how we go about it. There must be mandatory deadline, time of the essence. Time of the essence is again of legal relevance. It's not just a beautiful phrase. It is legally binding. Time is of the essence. So in other words, we should set up deadlines. So these are the negotiating processes and the doctrine that we are concerned about in these two seminars. Tonight we have a public lecture. Okay. So let's be clear. As an institute, we do not just provide sociological problem and understanding of it, but we need to look at the doctrines, the theories, and I can tell you this book tell you a lot with solid legal cases supporting. It's not just a talk. That's why when I read this book introduced by a friend, I was marvelous. I spent my time. I just don't have to reinvent the wheel. I just have to learn. But on top of that, I have more to add on and then discuss with him. That makes something so fertile. The whole ground is so fertile now for me. I hope it's for you, right? Okay. So I'm taking a little bit of time. No signal for me to stop. But let me introduce our speaker. Okay. First, let's welcome him, Mr. Vanugopal. He's been 30 years in Sabah, and then he is also originally from Selangor. So it's wonderful. He's been a citizen of Sabah already, right? He's a practicing lawyer, He handled quite a lot of heavy cases. I'll get to know it later when in the course of our conversation. He handled quite a number of heavy, important cases in Sabah. And now he is also with Sabah Bar Council, giving talks, giving sharing. Those are serious stuff. The judge is there, judging him. And then the other thing is that he most famously to me is this book. This book, I'm sure he has other books also, which is found in his forward here. Let me reiterate here, or let me tell you that he has published the following works. For example, this is by 2013. By now it should be on the list. Rules of the High Court 1980. Okay, Rules of the High Court. Then, so he checked the rules there. Hopefully you check our rules. And then the Case Digest and Precedent in 1996. Since then, perhaps more. As well as a guide to the Labour Ordinance of Sarawak, Amendment 8, 2005. So it is above the substance. He is about the guidelines and so on, rules. And of course, the Labour Ordinance of Sarawak. This is wonderful. I haven't seen this particular act yet. So the Labour Ordinance of Sarawak, 8, 2005, and that was in 2005, how many years ago? 14 years ago. So I can tell you safely, he is a very senior writer, author, lawyer, okay, and extremely dedicated to the works of Sabah and Sarawak. By knowing that he's from Selangor. Okay. All right. So let me also introduce a little bit about his credentials and his CV, perhaps. Vanugopal graduated with Bachelor of Economics, Economics, applied and honors from the University of Malaya in 1972. I was just a little boy, 1972, and further his postgraduate studies of this is the French word, Polish word. Studied at the Catholic University Leiden, Belgium. Graduated with a Master's in Business Administration with cum laude in 1980. In 1989, he obtained his LLB from the University of London. And in 1990, he completed the Certificate of Legal Practice CLP from the University of Malaya. He currently practices law in Kota Kinabalu, mainly in the areas of civil litigation and employment law. He is presently the chairman of the Sabah Law Association Subcommittee for the enforcement of the Advocates' New Remuneration Rules 1988. This is 2013, it's a bit out of date. You can change the CV later on. He has lectured at various seminars and workshops on labor, administrative, and industrial law, plus constitutional law. Okay, so I learned from him that he is now the chairman. Okay, good. Don't put that here. No. The chairman of environmental side for Sabah, which is now the key issues in England now. The fourth more important issue. I think Sarawak should follow up. Environment is such an important thing. Yeah. This is yours actually. This personal copy. Okay. So alright. So I have done enough. But I would like you to again welcome him again. Let's welcome him. Thank you very much. Again, I stress as a moderator, the more important thing is for us to ask questions, which he himself also requested for it. And feel free, you can talk in Mandarin. Let me translate. Jasmine here, who are the press people? Can I see? Thank you very much. For? Sihua. Oh, thank you very much. Jasmine is from Star. Is very professional. I invited her. I think I will give her a ticket. So thank you very much. Thank you. Welcome again, press, and all of you, distinguished guests. Okay, over to our speaker. Thank you very much.
Good morning, ladies and gentlemen. Thank you very much for inviting me to discuss with you the various issues affecting the various issues affecting Sabah and Sarawak. Maybe I do it. Yeah. I've accepted the invitation of Sahati Research Institute not to come and deliver a lecture. No, that was not my aim. But I've come here to share my ideas with you. I want to exchange my ideas, your ideas. There's actually nothing to teach about this because, as you know, law is something, the concern of everybody. And in such issues as the rights of the East Malaysian states, it all depends on from which angle you're looking at. Now, there is a handout that contains what I'm going to talk to you about, and for your, as well as for your review and for your comments. Now, there are certain things that I would like to throw out to you to test. I'm here not on a popularity visit, no. I'm going to tell you certain very fundamental things, which you may not, you'll be surprised to hear, but it's good to know what the others think about the same issues on which you have ideas. Those are my ideas, which I think are based on research of proper documents and the federal constitution as well as the state constitution. When I talk about the rights of Sarawak, it also means the rights of Sabah, because they are, both of them formed Malaysia together in 1960, and you cannot virtually, separate them out. Though they like to act independently, but you can't separate their rights. For this morning, I would like to specifically touch on the sovereign rights of Sabah and Sarawak over the oil and gas deposits. We all know that there are large volumes of oil and gas deposits lying in the continental shelf. Do Sabah and Sarawak have sovereign rights to them? You may say yes. Okay. But I would like to challenge it by saying no. I will say Sabah and Sarawak, based on research that I have made, may not have sovereign rights over the oil and gas deposits. This is what I would like to discuss with you this morning. Later part this evening, there will be also a discussion of a talk on the formation of Malaysia and the constitutional documents, the rights of Sarawak and Sabah, what were the rights that were given, and what the way forward. I've got the slide presentation, which you can also find it here. But it'll be good if you all just look at the screen, and really there's nothing much to notes to take, because everything that I'm saying is going to be, it can be found here. I would not speak for very long, then it becomes very monotonous and very boring. But I would like to, after speaking for a while, I would like to it's open for discussion. This way you can raise your questions. Of course, it is not possible to discuss these oil rights of Sarawak and Sabah without also at the same time discussing the other rights. So your questions may not necessarily be confined to this morning's topic, but they are quite wide. I will try to attempt an answer from my point of view. Now, the other thing I would like to tell you is that I'm not a politician. I've got no political inclination. I'm interested in politics as a citizen. I'm very keen in political development, but I am not attached to any political party. And the views that I express here are my personal. And I'm a member of the Sabah Law Society. Neither are the views I'm expressing the views of the Sabah Law Society. I've given a talk on a similar topic sometime back last year, and I was welcoming some challenges, but very unfortunately there were no issues raised. So please do not disappoint me this morning. Challenge what I've got to tell you. Because
Philip is here.
I'm also gathering facts for the book that I'm writing on this, exactly around this title, the sovereign rights of East Malaysian states over oil and gas. So please help me too by asking the question that challenge me. Okay, the starting point is I'll give you very briefly. Okay, the topics that I intend to go through very fast is the doctrine of sovereignty. And before that, you must understand we are in a federal form of government, and what's the meaning of sovereignty? Because that's a title, sovereign rights. So, what's the doctrine of sovereignty? The meaning and development. Then, sovereignty distinguished from jurisdiction. These are legal terms, but it can be explained properly. It's very simple terms. Next, I'll also touch on very fast on the formation of Malaysia and the constitutional documents. Next, Sarawak's and Sabah's claim to the oil rights and gas deposits. Then we'll discuss the Petroleum Development Act 1974 and the Territorial Sea Act 2012. The next would be the state's power to legislate under item 2C of the state list, pursuant to which now there will be the state government wants to impose permit and licenses, okay, requiring the explorers to do that, to pay. Next, I will also discuss with you case laws from other federal jurisdictions, United States, particularly United States and Australia. There are also similar cases also in Canada. Let's see what's the trend. It's important to understand for us these case laws because what's happening there, the courts here, if it is challenged, one day, will also look at what was the basis of the decisions in those federal jurisdictions. Then questions and answers. Okay, now let's start off with the. I think I prefer to scan.
Okay, are you want to stand here? Is it better?
This line is not long enough.
Okay.
I think this is
I see.
okay.
All right.
The dynamics of federalism. We are in the Malaysia is a federation of states. Federation of 13 states. You may not like that to start with. Okay, that's for you to challenge me later. Now, the federal form of governments often produce tensions between the federal or the central government and the component states. Now, and the major bone of contention is the conflicting rights to ownership of resources and allocation of grants. There are oil deposits in Sabah and Sarawak and in Terengganu and all those things. So the states want them. States say, hey, they belong to me. But the federal says, no, you are in the federal government, so it should be the right of the federal government. So there is some dispute. I mean, always in any form of, be it America or Canada or Australia. Now there are different, I'll go through this as a background. Then there are different types of federalism. One is the symmetrical, where the distribution of powers to component states are equal. Now there is also asymmetrical, meaning that they're opposite to symmetrical. That is, some states have more powers than the others. In a symmetrical or asymmetrical federation, okay, there is a strong centrally biased federal government enjoying great powers, plenary powers. Example would be Malaysia and India. They reserve, the central government reserves the large powers to themselves and they give some powers to the states. So Malaysia is one of them. Then there is a federal government where the federal government reserves to itself limited powers and the rest are shared by the states. In the United States and in Australia, the federal government has got really restricted, they call it enumerated powers, defense, security, even police is not, and currency and trade and foreign affairs. Other than that, everything is, including education, health, policing, all become state matters. Okay. That's very briefly on the type of federal government. Now, the basis of my discussion this morning is centered on the doctrine of sovereignty. Now, what's the meaning? Now, sovereignty is popularly understood to mean a final or supreme legal authority, implying an independent political society or statehood. Now, the existence of a nation state is premised on the existence of a sovereign because the government can only be carried out by means of laws, and laws can only be effectively administered if there exists some final authority beyond which there is no further legal appeal. That's the meaning of sovereignty. Supreme. There is no other further authority over that authority. And that's the authority, that's the source. That authority is the source of all laws. Then it is sovereign. Every country in this world, every state in this world, when I say here state means not the component state, here I use state in an international term meaning country. So every country or state in this world which is independent and which has got supreme authority to make laws and which other states, other countries in the world recognize, then it becomes then you can say it is a sovereign country or sovereign state. These two, Rousseau and the Hegelians. Hegelians are those who believe in rationalization. Okay? Sovereignty means a supreme authority which is also completely moral, which is a good government, good governance. To others, it means supreme cohesive power exercised by a determinative body of powers possessing monopoly over instruments of cohesion. They have got the powers to enforce the laws. If you break the laws, certain punishment will follow. Now, the origins in Roman law. Sovereignty was first discussed and developed under Roman law. There are two concepts that are important, imperium and dominium. I wish Alex was here because he has written articles on imperium and dominium. Now, so these two concepts are very important particularly in understanding sovereignty in a federal government. Imperium was developed in the realm of public law to defend the exclusive supremacy of the emperor over other temporal rulers and lords. It is a supreme authority, means vested in an individual. That is imperium.